You know, in the huge, complicated world of civil lawsuits, there's this one document that can literally change everything before a trial even gets off the ground. And no, it's not some dramatic last-minute piece of evidence. It's the pre-trial conference brief. Today, we're going to break down exactly how this simple-looking document can completely shape the outcome of a case. So here's our game plan. First, we'll set the stage and figure out why these conferences even exist. Then, we're going to zoom right in on the brief itself, dissecting the 5 key things you absolutely have to include. And we'll wrap up by looking at the incredible amount of power this document gives the judge. All right, let's dive in. Picture this. Way before you see any of the courtroom drama from TV, the lawyers and a judge actually get together for a meeting. Now, it might just sound like a simple chat, but this pre-trial conference is, without a doubt, one of the most important moments in the entire process. But you're probably asking, what's the point, right? I mean, if you're already headed for a trial, why bother with this extra meeting? Well, the answer really gets to the heart of what the modern justice system is trying to do. Rule 50.01 of the Rules of Civil Procedure pretty much spells it out for us. Goal number 1 is to see if there's any way to settle the whole thing without the massive cost and time of a full trial. But, even if that doesn't happen, the second goal is just as important, to make the trial that does happen as fair, as fast, and as cheap as possible. So, how do you make all that happen? Well, it all kicks off with one single document, the pretrial conference brief. Seriously, you should think of this thing as the master key that unlocks a really productive and maybe even case-ending conference. Think of this brief as the official roadmap you hand-deliver to the judge. It's your first and, honestly, probably your best shot at framing the entire story of the case from your point of view. It's where you lay out the key facts and your position, all nice and clear, long before anyone starts making arguments out loud. And this is the most important part, something that kind of goes against every lawyer's instinct. This brief is not the place for big, passionate arguments. The rules are super clear about this. Concise statements without argument. Your job here is to inform and clarify. That's it. The big fight comes later. Now, to make sure these briefs actually do their job, the rules of civil procedure don't just leave it to chance. Rule 50.04 gives everybody a very precise checklist of what they must put in there. So let's break it down. Okay, there are 5 core parts. First, just a simple summary of what the case is about. Second, a clear list of what everyone is fighting over, the facts, the law, and where you stand on each one. Third, who you plan to have testify, and a real estimate of how long that'll take. Fourth, a little status update on what's left to do before trial. And finally, your opinion on whether it would make sense to split the trial into different parts. Now, beyond what actually goes in the brief, there is one other number you absolutely cannot forget. When it comes to this document, it might just be the most important number of all. 5. That's the magic number. Rule 50.04 is crystal clear on this. The brief has to be filed with the court and given to everyone else involved at least 5 days before the conference. And that's not a suggestion, it's a hard, non-negotiable deadline. So you do all this work, you get it in on time. What's the payoff? Well, a really solid brief does a lot more than just check a box on a to-do list. It gives the judge the tools they need to take real control of the conference. With your brief in hand, the judge can start working through the official agenda from Rule 50.06. They can really dig into settlement options, try to simplify the main issues, and push the parties to agree on certain facts, what lawyers call admissions, to make the trial go smoother. They'll also get into the nuts and bolts, like how long the trial might take and who's testifying, all in the name of efficiency. And let's be clear, the judge isn't just a referee here. Under Rule 50.07, they have real, actual power. They can set a binding schedule for the rest of the case, they can move the trial date, and they can make pretty much any order they think is necessary to keep things moving. And here's the part you really gotta get. Any order the judge makes in this conference is binding. It's not a suggestion, it legally locks everybody in, and the only way to change it is if the trial judge later decides it would be a major injustice. So yeah, the stakes are incredibly high. So when you boil it all down, the pre-trial conference brief is way more than just a piece of paperwork. It's a strategic weapon. It's your chance to frame the story, to influence the agenda, and to get your case on the best possible track, whether that's a great settlement or a much simpler trial. Which, it makes you wonder. In this whole legal process, with all its complex arguments and fancy motions, Could it be that this short, factual, non-argumentative brief is actually the single most powerful document you file? Definitely something to think about.